to page 2. Under current law, the Municipal or Regional Planning Commission can hold a hearing on the proposed plan. This gives them the ability to ask the applicant or the BPS or both to attend a hearing, and if they're asked, these people have to comply and attend. It directs that the department consider comments made and information obtained at the hearing when the department makes its recommendations to the board once the application is filed. It also, they may not attend this hearing
I
now.
don't understand the dependence, but we have to put a condition in there that they listen to the evidence. They may listen to the evidence.
This directs them shall consider comments. They may do it now. It says shall.
Shall do what with it?
Consider them in making recommendations.
Okay, this is the Regional Planning Commission, not the board. Right? This is the Regional Planning Commission.
Or the muni.
So the working
Or
group,
muni, yeah.
this language mirrors language that's in the telecom facility siting statute now that the General Assembly added a couple of years ago, and the working group recommended that it also be adopted for energy facilities.
Okay.
So Eric, the planning commission may request, so if they do request, they have to go and that information has to be considered. If they don't request, they don't have to go, and therefore that information does not have to be considered.
Correct. Department still may consider information that it receives as a result of that hearing. Page 2, sub B, actually asks, this also mirrors the telecom facilities statute. You added either last year or the year before the ability of a municipality to ask the department to retain experts during the 45-day advance period. And this would allow the department to do that for energy facilities as well. And it basically, the department has authority today, once the application is filed, to retain experts and allocate the costs to the applicant. This would allow the department, at the request of the municipality, to do so during the 45-day advance period.
These are energy facilities.
Right.
Not telecom.
This here is energy. Telecom already has this.
Okay.
And the working group was saying make it the same.
Okay.
The department is not obliged by this request to agree with the position of the Municipal or Regional Planning Commission. So the expert may or may not come out where that commission wants it to, want the expert to. Also on page 3, under current law, it requires the commissions to make recommendations to the board and the petitioner at least 7 days prior to filing the petition with the board. The working group recommended allowing the commission's recommendations to be filed after the application is filed. So, in other words, the board would get their recommendations later rather than before the application is filed. Right. Yes. Planning commission's recommendations. This does is say, okay, planning commissions can make recommendations to the petitioner, the applicant, during this 45-day period, and then once the petition is filed with the board, can make recommendations to the board. The working group actually had asked for this to be a straight 21 days for all facilities. This language actually makes that deadline the same as the deadline that would apply to all parties in a particular proceeding. Because in fact, you have different deadlines in boards, in statute and board rule, depending on what kind of energy facility it is.
So this makes them all the same.
No, this basically just says,
No.
you file your comments at the same time everybody else has to file their comments in whatever energy proceeding it is. So for example, if it's a net metering facility, the current rules say 30 days. If you applied a blanket 21 days, you'd actually be short-changing the Municipal and Regional Planning you get the same 30 days that everybody else has. There's a whole nother statute, I know I'm getting weedy here, but there's a whole nother statute for applications of limited size and scope where comments are due 28 days. So this says, okay, if it's one of those applications, it's 28 days. You just track whatever it
Okay,
is.
so it's you, all right, but everybody has to file at the same time
Yes,
in whatever time frame is set out by that.
by that statute or that rule. And in some
Okay.
cases, the timeframes are established by the board, because there is no statutory rule.
Okay,
So that is what's happening in the first section. The next several sections address a recommendation of the working group to try to standardize how, when applications are sent to all parties, to make sure that the board, before the applicant serves the application on all other parties, does the board reviews it for completeness. And that what all other parties get is a complete application. The board is determined to be complete. And they get that within 2 days of that determination by the board. And then that 2-day period, the end of that is what starts the clock ticking for filing your comments. So everybody, the idea was to try to put everybody on the same page. You get a complete application, and the clock starts ticking at the same time for everybody, instead of...
so that
It
would
might-
be the developer of the energy site, the local neighbors, the regional planning commission, the town planning commission, they all have the same number of days starting at the same time.
Yes, well, the developer would be usually the one who's filing the application.
Yes.
So the developer would file an application with the board. The board would review it for completeness. The board would tell, let's say it's complete.
Okay. On May 1st, it's complete.
Then the applicant under this would need to deliver the application to all the other parties by May 3rd.
Okay.
And then the period for comment starts running on May 3rd.
And all the other parties start with the regional planning commission,
The town planning commission, the town
Town.
legislative body,
okay.
adjoining property owners receive notice.
Joining or budding?
Adjoining.
Sure. Because there's some things like, there were complaints that somebody one door down who looks catty corner. I had a complaint from a neighbor on Northfield Street who found out that the solar array, she doesn't technically abut, but it's all she sees out her kitchen window.
Well, I'm
So
not,
is-
so the language that the board uses in this rule is
Joining.
adjoining. The statute actually doesn't require notice to adjoining landowners, it's board rules. The statute requires notice to a list of state agencies and local and regional entities. And adjoining,
I assume that's a butt. They're touching.
adjoining means touching unless you're separated by a right of way like a road or a waterway.
Right.
So if you would be touching but for the
But for the-
intervention
right.
of that right of
So
way.
the folks across the street would get notice, but not the
But it-
folks one door down who are gonna look at it. 2 doors down.
Where are we? 'Cause I don't see any reference.
We're right on line 13, page 3, I think.
Yeah, but there's 3.
Yeah.
No,
Yeah.
I've been just describing what the next several sections do, and the sections do not contain language about adjoining property owners. That's in board rule.
Okay.
Senator Cummings was asking me who normally gets these notices.
Like word rule.
Yes.
Okay,
So-
what is the temporary siting of meteorological stations?
So
Ask
section-
that?
Yes, section
All
2
right.
is, has the board issuing certificates of public good for temporary wind measurement towers. And this is the first of several sections that applies this standardized time frame.
Okay.
So you'll see on page 4 that when you apply for a CPG, temporary Met Tower, as they're often called, you first file the application with the board, and then you get notification from the board that the application is complete, and then you have to deliver copies to certain entities that are listed on
Okay,
page 4.
I've never been on natural resources, so I'm about my pay grade here. Is a temporary meteorological station the first step in deciding you're going to put up a wind turbine?
It usually, to my knowledge, it usually is.
Okay.
It
It's
is
like
also
the logging
possible-
road that says we're going to apply for development here soon. That's also urban legend.
It is also possible to put up a meteorological station simply to measure.
Right.
for-
But
If you were, say, a research
I don't
institution or
think anyone
university.
cares if you're measuring for research. But this would give early notice to the surrounding area. It would be an alert that somebody was measuring the wind on their ridge line and they might want to be aware of that.
This is existing law, and it probably does have that effect. The only the change that's being made here is just, it's not,
Right.
It's micro. It's about it's about standardizing the 2-day.
Is there anything that differentiates between I want to put a temporary Met Tower up because I'm a scientist and want to know about the information that will give me versus I want to put a Met Tower up because I'm thinking about developing this into a wind farm?
No. Under the law as it existed before Section 246, that was an issue because the board asserted jurisdiction under Section 248.
Sure.
If the applicants, if this was a precursor to an electric generation facility. And then you could get into a disagreement about what you could get into a disagreement on what the intent of the person doing the facility is. Here, it's just, if it meets the definition of a temporary meteorological station, then you have to get a CPG.
So, regardless of what your intentions are for the Met Tower or what information gathered by the Met Tower, you still don't have to divulge those when you go for the CPG for a Met Tower.
I believe that you do not have to divulge your intentions, but I haven't looked at that in some years.
I think the chair's going to be quiet, and we all will, because Aaron's got about 5 minutes.
Well-
So we'll do a quick walkthrough.
I told them to anticipate that being late.
Okay.
You're gonna tell us.
Yeah.
Yeah, don't
Don't
tell
worry
us.
about it.
We're gonna, but let's walk through it. We are not voting this out today. Anyone that wants to testify, give your name to Andrew. And we'll get you in. Okay.
So, Section 3, we're going now from temporary meteorological stations to Section 248, which is electric generation and transmission facilities and natural gas facilities. This again is on page 6. Having service, having delivery of the application within 2 days of notification.
We're standardizing the timeframe.
Right. Across several different processes at the board. First we did Met Towers, now we're doing energy. Section 4 is also energy. It actually is the so-called limited size and scope process for energy facilities, which you can think of, if you are familiar with Act 250, as analogous to the minor permit process of Act 250. And if you're not familiar with that, then that's not a helpful clarification, and don't worry about it. But
I remember it drawing, and I remember you could go like that instead of like that. You could,
well,
when it got presented couple of years ago, last year.
Senator Lines, does this incorporate all of the recommendations, this bill? Senator Lines?
It incorporates all the recommendations that require some statutory change.
Okay.
So there are other recommendations that are,
Administrative.
well, they are administrative, but I think as you go through the bill, you'll see a section of report back on the progress you've made. And there might be some things that would be best placed in statute to ensure that they don't change going forward.
So what's happening in section 4 again on the limited size and scope applications is the 2-day, the notification that it's complete and delivered within 2 days after that, and then your 28-day comment period runs from that 2 days.
Okay, so what we're saying is everybody has, once it's ruled complete, they have 2 days
Plus the comment period.
to notify all the interested parties, which are defined in rule or law.
Yes.
They notify all of them, and then there's 28 days starting with that notification that you're complete.
Sorry, no, it's 20, so it's, the applicant has 2 days to deliver
Right.
the application, and then the 28 days for limited size and scope would run from the end of that 2-day period. So
Okay.
nobody's
So you've got
comment
30
period is
days,
being
you've got,
reduced.
all right, you've got 30 days from the day the application is ruled complete.
But, right, but the party yourself, you're the
Right.
town, you'll probably get it
2 days
2
after.
days later,
Right,
or no later than 2 days later. So your
Right.
comment period, the idea is that that's,
you have 28 days to comment.
Right.
But it's the same for every hearing, so you haven't got a select board with a volunteer secretary out there trying to figure out, I've got a solar project here, and I've got something else there, and this one has 22 days, and this one has 30 days.
no, that's,
There.
no, it's just that here, there are actually, that's a whole different issue of standardizing the period for comment, because you actually have multiple comments.
Okay, so you have, that's when it
This
starts
just
sticking.
standardizes when it starts sticking.
Okay, sorry, we did do that, all right.
Quickly, what's the repercussions if they don't,
If who doesn't?
if the petitioner does not deliver copies of the completed petition?
Then the
what-
comment period won't start to run.
So the comment period starts to run when all of the boxes of those people who need to be informed are informed.
Well, the comment period runs within 2 days.
What I'm saying is, what happens if the petitioner fails to abide by this new standardized?
Can
Doesn't matter.
delivery be by email?
Yes.
Yeah.
Okay,
Um,
so that leaves out the snow.
I understand the point. I would believe that, I think that might need to be clarified here, but if,
It's a great
Yeah.
concept.
Right,
right,
but
If
there
they
are,
get
there
them
are,
2 weeks later and the comment period's 14 days, what's the repercussion,
so,
right? That's all I'm asking.
so I think ultimately the repercussion would be that the party did not get the notice to which it was entitled, it could raise objections and possibly hold up the application, and, or it might even be possible, the board would have to say, sorry, we gotta start this over again.
Sure, which I would think would make sense.
Um,
Clarify it. Or the other job.
Well, if you want to clarify, it's my job to write it, so
Right.
yes, section 5.
okay, and this is the one Marge Garfield had a question about. She didn't remember it being part of the recommendations and just, I don't know why it was
But
in.
it's only in there now because we're doing that 2-day thing.
So 248A was listed in the recommendations,
Okay,
and to standardize this 2-day, board reviews application for completeness, and then within 2 days of notification of complete.
okay, so it's the same
the
2
application
days.
of parties. It's
That's
Just the same 2 days.
Okay,
Bringing
that's
everything
a
into
simple
compliance.
explanation.
So,
So I noticed here that there's specific existing statutory language on adjoining property owners.
yes, that's for telecom facilities.
Okay. Is there anything to be concerned about that, all these other ones we list, a laundry list of 3 or 4 people to get notice, and we don't say property owners, and we leave that to the board to make up that decision? Should we just take the opportunity now and put that in?
Well, that's a policy decision. If you don't put it in, it's still up to the board and how it could repeal its rules someday.
Something new.
So, on section 6, moving to a different topic, the board wanted to standardize how it gives notice of a petition for a different kind of certificate of public good. This is a certificate of public good for a business rather than a facility. Someone who desires to engage in a business over which the board has jurisdiction. And so, for example, GMP itself should have, and I believe does have, a CPG to be a utility. And, you know, for once, and all the other utilities in the state have such a CPG. The current statute requires newspaper publication and circulation 2 weeks successfully in a newspaper, 2 weeks successively in newspaper general circulation.
That's getting harder and harder to do.
So the board, right, and actually that was changed in other parts of Title 30, for example, in Section 248 a few years ago. And the working group asked for the language in Section 231 to mirror what is now in effect for 248, which you'll find that concept embodied in language on page 10. So you publish notice of the hearing on the website and once in a newspaper general circulation, which is what is done today for Section 248.
Is that people don't generally check the website. It's not one of my favorite reading spots. If I don't, I mean, the notice is to let you know something's being planned.
Right.
So if I know that something's being planned, I'll check the website. But if I don't know there's something going on, I'm not going to check the website. I wouldn't even know where to get
We would be
the
going from
2 weeks in the newspaper to website and 1 week on one newspaper notice
from just one newspaper. So
and
that's-
website notice at least 12 days
So
before.
if I'm doing this in Franklin County, a newspaper of general circulation would be the messenger, and successfully for 2 weeks, that's 12 different appearances now going to one.
I think it would be once in each week.
Yeah, I think it would be nice.
If we're just going from 2 to 1, that makes sense. 1 to 6 to 12.
I believe the way this has been administered is 2 to 1. And that's how I thought it. That's what I thought it meant.
And it gets noticed in the legal notice.
Yes. I believe it gets noticed in the notice section, actually. So I say yes, but I don't do them.
And I assume the public service board, your department's website,
Yes, the board's website
the board's website.
says here on my side.
You check that regularly.
Yeah.
So,
In front porch forums, municipal websites tend to get more.
you may have a policy issue on how you want to accomplish
Well,
notice.
the world of, you know, our local newspaper is the Times Argus. The fallback from that was the World, but the World now isn't distributing to houses. Argus is only publishing 5 days a week, 6 maybe.
6,
5. Yeah, so it's, and readership and all of them just dropped off because,
So we can do our part by making these petitioners spend money with the local newspapers.
So,
yeah, I mean, but people of a certain age don't spend their days checking websites. So I suppose you then would rely on your local town or planning commission to notify.
Well, and actually, Ginny might know this more, but if you're gonna do pesticides, you have to go on the radio, right? You have to do that kind of stuff. You do a pesticide application, you have to go on the local radio station.
Okay, let's
So
red
maybe we
flag
flag it, and
this.
we'll look at other ways of notification.
So I think as a testimony is given, that maybe there'll be some help. I, for one, as we talked about this in the working group, there was support, there was more support for having it be one notice than two. I'm happy with two, as it has been, but I think the board will be testifying about their improved access and information by website and their EPSB. So I think, let's
That's
see
only if you go there.
let's see what they have to say too.
But that I've just got flagged. Okay. Keep going.
So section 7 implements a recommendation of the working group to allow the department to enforce conditions of certificates of public good for energy and telecom facilities and the various related statutes in a manner similar to what the department does today for a program called DigSafe.
Okay. I was wondering how big safe got into this. All right.
So this would amend the penalty statute of Title 30 to allow that to happen. And it's mirrored very, the language is very much based on the board's ruling regarding enforcement of DigSafe.
I'm watching the time because we are supposed to have someone on the phone 4 minutes ago, so.
So I
That's
could
good.
come back and finish this another time, but maybe what I should do is leave this in a very broad place in section
Yeah.
7.
Okay.
The first part of this is clarifying on page 11 that this section applies to violation of conditions of the CPG. I read it to apply to that today because it talks about violating a decree of the board, and I think the CPG is a decree of the board. But I think it doesn't hurt to clarify it.
Belts and suspenders.
And the real meat of this starts on page 14, where the department can investigate a complaint about a violation of CPG and issue a notice of probable violation.
Okay.
And then that would automatically open an enforcement proceeding before the board, and the respondent would get a 30-day period to respond and identify and request a hearing and identify issues for the hearing. And then the board, then you can go through a hearing process if requested. The one issue that is addressed in here that is kind of a weed but may be important is to how does the person who has to respond to a notice of violation find out information supporting the notice?
Probably in that one.
No, it's a cell phone.
There's a cell phone going off. Somebody has a cell phone. Okay.
So this is a fairly detailed provision. So it may make sense for me to go into the details and understand your constraints. But there is provision for the notice, the opportunity through a public records request to get information from the department underlying the notice, and then you can respond. And then if you're in a hearing process, you would go into a formal hearing process and the board would issue a determination.
Okay.
And
And
if that,
this is all new code.
then, so there may be, I expect that the details of this could be significant to parties, especially to the board department and potential people who are subject to CPGs.
Okay.
But I'm going to move on to section 8.
That's the name change.
Changes the name from the Public Service Board to the Public Utility Commission. Public Utility Commission is a common name in the U.S. country for a commission that regulates public utilities. You can also find Public Service Commission. There are a number of other names, possibilities. This bill does not attempt to amend every statute in which it says Public Service Board or board.
That's somebody's summer task.
It amends the basic statute that establishes the board, 30 VSA Section 3. It amends a couple definitions, Sections 9 and 10 in Title 30. And then it gives in Section 11, basically, the task is to my office to find the rest of the mentions of the Public Service Board and change it to the Public Utility Commission. If you decided to go with this, it might be possible to add more of those provisions before you have a committee.
Okay.
Section 12 would direct the Division for Telecommunications and Connectivity within the department to submit a plan to achieve citizen access to hearings and workshops of the board for remote locations across the state. This is an attempt to replace the services previously provided by VIT, but would not necessarily be the same mechanism.
Okay. Could be Skype, could be whatever.
Yes. I don't know if Skype would work or not, but it might.
So we did this before VIP?
She's gonna get the whole thing.
The board used VIT. It's not,
So you don't have the IT anymore.
Right, and so the question was, are there better ways to do it than VIT? It may be Skype, it could be Dan, you know, the
No,
local.
totally understood. But we
Yeah,
haven't
so,
done-
okay.
so we haven't had this option since we got rid of VIP.
Right. Not really. And if the hearing's in January, in the middle of a blizzard,
Yeah,
that
you
limits
gotta
participation.
get out in the blizzard.
Been the same issue.
They canceled.
Yeah.
Canceled.
Okay.
So, lastly, section 13 is a report by the end of this year for the Public Service Board to follow up on the implementation of the recommendations, and particular mention is made on lines 15 and 16 on the ones that don't require statutory change.
Okay. And we'll go over that.
He's getting it.
Report.
Okay.
We'll go over the report on another occasion. Okay. Thank you. Good luck.
Is this something that we need to move before crossover, or is this
All
something?
things need to be moved before process.
Well, so this, so my question is, so this cannot be attached to anything that's coming to us per se. Our goal is to get it by
Our
crossover.
goal is to get it out.
Great.
And I have no idea what's coming
Yeah.
at us.
Yeah.
It might, it's probably anything we'd attach it to would be in in natural resources.
Right.
Okay. Can we get Annette?
Yep.
And Annette is going to be talking
Yeah, I agree.
about.
It deserves something else.
There it is. This is Annette, okay.
So there are a couple places in the, when we go through the recommendations another time, there are a couple places where members of the working group were very adamant about having certain recommendations to ensure transparency of process. There are other places where a member wanted to go a little bit further than the report, but it was much more complex than we could do and might have stepped into areas that were difficult. So as an example, one of the areas in the current proposal and in the recommendation, allowing for towns to have some technical expertise and to pay for that so that they can understand the project. So
Okay.
town and some folks wanted to have intervenor funding overall, not just for municipalities, but that was where it got really tough to figure out.
Okay, we're gonna have Annette next to testify on this.
To complete calls beyond your local area, you must dial 1 plus the area code. Do not dial 1 when making a local
It's
call.
not a cell phone.
Thank you for using Fairpoint.
Pretty common practice, Andrew.
Yes. No, we've had major problems next door with this.
Yeah.
Yeah. No,
No practice.
no, take your time, don't worry about it. We'll get there.
Whole room of people watching you do this.
That's the worst. Do you have any difficulties, Senator? We will take over.
I got this. Jeez, this is awful.
Let me see if I can find
An adult? Can we get an adult?
Hey,
I mean, all of us.
Remember, we had this issue, you know how to fix it?
give it to you though, I'll do it.
Okay. 3232 works also.
Imagine 3232.
Three?
Uh-oh, it's, I did it wrong.
You're on. You're on camera, everyone.
Go ahead.
See you legislators.
Well, we'll switch chairs and now we're learning to dial a phone today. We're having a very good day.
Now,
There you go.
I agree.
There you go.
Hello?
Hello, is this Annette?
Yes.
Hi Annette, it's Ann Cummings with Senate Finance Committee, and I apologize for being late. Took us a little longer to go through the bill than we anticipated. So the floor is yours, and it's yours.
Thank you very much.
Okay.
My name is Annette Smith. I am Executive Director of Vermonters for a Clean Environment. Thank you, Madam Chair and the committee, for inviting my testimony today. For the last 2 years, I have worked with Vermonters involved with solar projects to assist them in participating in the process at the Public Service Board. For nearly 8 years, I have worked with Vermonters involved with wind projects and have assisted towns and neighbors with their participation at the PSB. I have also worked with Vermonters on biomass plant applications to the PSB. Senators Lyons, McDonald, and Sorokin may recall I asked to testify to this committee last year after the Attorney General's investigation, following up on a complaint that I was engaged in the unlicensed practice of law by assisting Vermonters in participation at the PSB, was closed. The summary of my testimony was that the AG's investigation proved that the PSB is a legal process and the public gives up rights when they attempt to participate without a lawyer, and the public needs a lawyer. The day after my testimony, the PSB working group was added to S-230, which became S-260 and enacted as Act 174. I was invited to present to the Act 174 working group and offered substantive input on problems and solutions. S-52 proposes amendments related to PSB proceedings based on the recommendations of the working group. The purpose of S-52 relates to the public's access to PSB proceedings. Before I comment on the specifics in S-52, I would like to offer some new perspective on the challenges that Vermonters who are neighbors of proposed renewable energy projects face when confronted with a project in their community. These challenges extend to towns and regions, not just neighbors. My thinking on this topic has evolved in the last year, and especially in recent days because of a recent PSB order. I have realized that the problems the Vermont public experiences with the PSB process go beyond the specifics of what happens during PSB proceedings and are much more extensive due to the statutes put in place by this legislature, the way the PSB is interpreting those statutes, and the PSB's ability to make a finding of the public good, which is not defined. Senators Campion and McDonald may recall my testimony 2 years ago on H40, which became Act 56, to the Natural Resources and Energy Committee, in which I pointed out that the PSB has come up with its own version of the aesthetics analysis known as the Queechy test. Act 250 and legal precedent include neighbors as the average person when evaluating the undue adverse aesthetic impact of a project. The PSB standard, as applied to solar and wind projects, has excluded neighbors based on an opinion of 2 experts paid for by Green Mountain Power in the 1996 Searsburg Wind Project, a case that was not contested or appealed. Yet the PSB adopted the opinions as their standard, deciding that the neighbors cannot constitute the average person when they are most likely to be impacted and, quote, therefore have an individualized perspective which is different from the viewpoint of the average person, unquote. The legislature has attempted to fix that problem for net metering systems that exceed 150 kilowatt plant capacity, and the new net metering rule may address the problem, but as it stands now, neighbors of non-net metered systems will continue to be excluded from consideration under the aesthetics analysis as it is being carried out by the PSB. and the legislature have set up a catch-22 circumstance for neighbors of energy projects, whereby the only way Vermonters can participate at the PSB is to show that they have a substantial interest, which may be adversely affected by the outcome of the case. And they must show they have a particular interest, which the PSB has consistently interpreted to be primarily a property interest. But then the PSB has concluded that neighbors of solar projects should not have their aesthetic interests considered, and most recently that neighbors of wind projects are considered individuals who, quote, do not collectively raise a public health concern, unquote. The PSB directs neighbors of wind projects who cannot sleep at night to seek, quote, any individual relief that may be available to them in a forum that has the requisite authority to review their personal circumstances and to take action as may be warranted, unquote. On Friday, Vermonters for a Clean Environment filed comments on the PSB's draft rule to establish sound standards for wind generation projects, in which we said, quote, the board has created a deceptive and dishonest situation for neighbors of wind turbines in Vermont. On the one hand, neighbors who have a particularized or individualized interest are invited to move to intervene, and their right to intervene is based almost entirely on their property interests. On the other hand, when neighbors complain about wind turbine noise trespassing on their property and disrupting their sleep, the PSB tells neighbors that the PSB has no legal interest in protecting the neighbor's health or property interests. Under the PSB's construct, it is possible that every community in Vermont could host wind turbines that negatively affect nearly every Vermonter, yet each of these Vermonters would be considered individuals and not the public. The role of the Vermont public as it concerns neighbors of energy projects and their participation in the PSB stands in contrast to the PSB's determination of the public good. In 2011, in its 2011 decision approving the Green Mountain Power Lowell Wind Project, PSB Chairman Foltz dissented on his fellow board members' attempt to address the problem caused by wind turbine noise, trespassing on developable land owned by neighbors, in which he wrote, quote, balancing the state's renewable energy goals with the impacts on surrounding property owners is a broad public policy decision that should be made by the legislature, not this board, unquote. Due to ongoing frustration with the PSB's handling of noise complaints from wind project neighbors, last month I wrote a letter to the PSB. In response, PSB staff responded, quote, with respect to your more general comments and concerns, the board takes the issues surrounding sound from wind facilities very seriously and is fully engaged in its efforts to produce a rule for regulating such sound emissions in a manner that is consistent with protecting the public health, but at the same time does not create an impossible barrier to the deployment of wind power generation facilities, consistent with the state's policy objectives regarding the deployment of in-state renewable energy generation as set forth in several Vermont statutes, unquote. I wrote and asked what statutes were being referenced and received this response. Quote, I had in mind when I wrote the letter 10 VSA section 578 and 30 VSA sections 8001, 8004, 8005, 8005A, and 8007. That's an email from board staff member John Cotter, January 11, 2017. Further compounding the problem for Vermonters who find themselves in the role of neighbors of an energy project is the statute that enables renewable energy plants built in Vermont to serve the New England region, not Vermont. Right now, Ranger Solar's 4 20-megawatt projects and Swanton and Irisburg Wind are all proposing to sell their power to Connecticut. This is deemed by statute to be in the public good of the state of Vermont, even if Vermonters do not use the power. The question then becomes, what role do Vermonters play in the PSB's process for approving energy projects? Is there any point in intervening as a neighbor when each neighbor is viewed as an individual and not a member of the public as it pertains to the finding of the public good? This problem extends to towns and regions as they too are not incorporated into any consideration by the PSB as they apply the public good. Indeed, the planning criteria and process being carried out as part of Act 174 may be an exercise in futility, as the PSB's public good will always be able to trump the substantial deference given to town and regional plans that have been crafted to meet the DPS criteria for certification. This committee is the committee of jurisdiction of the PSB, along with the House Energy and Technology Committee. It would have been best if the PSB chair had come to this committee years ago to seek changes in statute that would enable neighbors, towns, and regions to have a say in the consideration of renewable energy projects. Since that did not happen, we We are now in a situation where the PSB says we are just doing what the legislature has told us to do. It is up to you, the legislature, to make those changes to assure that Vermonters are considered when energy projects are evaluated by the PSB and that the participation is meaningful. The dynamic now, as set up by this legislature, is one that has left nearly every Vermonter who has participated in the PSB as a neighbor or town saying when it's over, it's as though we weren't even there. Neighbors and towns are trapped in a nightmarish circle with the PSB using the legislature as an excuse for their rulings that consistently ignore or trample on the rights of the Vermont public, while the legislature has steadfastly defended the PSB and refused to make that broad public policy decision as recommended by the PSB chair in 2011, or consider any changes to the process. What is the point of Vermonters raising tens of thousands of dollars necessary to participate in the PSB when the PSB will always find that the public good is served by building energy projects, even if they don't serve Vermont but provide power to the New England region? If it is the intention of this legislature to exclude all Vermonters from meaningful participation in the PSB's consideration of approval of energy projects and the impacts of their operations after construction, it should be clearly spelled out in statute so that Vermonters are fully informed about their rights and options. In the alternative, this legislature and the PSB must stop pointing to each other as the reason Vermonters are being disenfranchised by the process and take responsibility for changing the statutes that are guiding this Catch-22 circumstance so that the PSB incorporates the people of Vermont into their consideration of the public good. And now I will move to the bill itself with my comments on S52. On page page 2. And now I will move to the bill itself with my comments on S52. On page 2, 1AB, this sounds good, except the department works for the governor, and depending on who the governor is, the experts hired can be biased, as has occurred with the noise experts hired by DPS under Governor Shumlin, all of whom work exclusively for the wind industry. Time frames may or may not work for municipal and regional planning commissions, depending on when 45-day notices are filed. There is not a lot of time to warn a public hearing. Many regional planning commissions do not meet in December, July, and August. Page 3, section 246. Meteorological stations now can also use LiDAR and SODAR boxes with no towers. NextEra put a SODAR box up on a mountain in Berkshire, and no PSB CPG was required. Please add LiDAR and SODAR to this section. Met towers and the lack of connection to wind turbines in the PSB process is a recurring problem, as the Met towers are always precursors to wind turbines, yet the PSB treats them as entirely separate projects. Met tower data is used to prove the financial viability of the project to potential funders, but it plays no role in the PSB application for wind turbines. Vermonters have been asking the PSB to require that the Met tower data be made public and connect Met towers to wind turbines in the application process. Currently, the PSB is not looking at the data and has no idea if a wind project can actually produce what the developer says it will. There are currently 2 examples of wind developers who have erected Met towers without obtaining a CPG. The PSB has opened investigations in both cases, and the developers are applying for wind turbine CPGs while the PSB process for the Met tower investigation has not yet been resolved. This creates undue burdens on neighbors who must participate in both processes concurrently. See this log, and there's a link, of the Swanton developer's Met tower without a CPG docket, which is dragged on since July of 2015 as the applicant challenges the party status of the neighbor who filed the complaint. PSB issued the scheduling order for the Met tower case on February 2, 2017. The PSB issued the scheduling order for the Swanton wind turbine project on January 20, 2017. I hope you will all take a look at all 3 of those links to see what kind of a process this is for the people who are involved. The Langs, who filed a complaint about the Swanton Met tower without a CPG, are currently the only neighbors of the Swanton wind project who have hired an attorney and intervened in that docket. It is unfair to Vermonters to allow wind developers who have flouted the law requiring obtaining a CPG for a Met tower to benefit from the data gathered and move forward with an application for wind turbines while the Met tower violation is unresolved. A similar situation is occurring with David Blittersor's Met tower without a CPG in Irisburg, where the town of Irisburg has intervened. Mr. Blittersdorf has filed a 45-day notice for 2 wind turbines on the same site as the Met tower and his wind turbine application is expected soon. The statute should be changed to require resolution of Met Tower violations prior to acceptance of applications for associated wind turbines and require the data from the Met Towers to be part of the application for the wind turbines. Page 7, Section 248A, Certificate of Public Good for Communications Facilities. This is primarily a land use issue that should return to Act 250 jurisdiction. The PSB's process is a virtual rubber stamp, and when parties intervene, it can be unnecessarily expensive. Page 11, section on penalties. The PSB recently ignored this statute when issuing a fine on January 13, 2017 to Georgia Mountain Wind for violating its winter operating protocol by running the turbines under icing conditions. Senator Campion was a witness to the icing event in March of 2016. On January 30, 2017, DPS filed a motion to reconsider, which details the failure of the PSB to comply with the statute. The neighbors also filed a noise complaint, as the noise was the loudest ever experienced, which the PSB has ignored entirely. Nothing in this process provides relief to neighbors who are being harmed by the violations. Fines go to the general fund, as levied recently by the PSB, are not a deterrent to future violations. Georgia Mountain Wind is majority owned by David Blittersdorf, who has been the subject of 4 investigations at the PSB over alleged violations, and he is proceeding with 2 more turbine projects. Vera, his consultant, was the consultant to the Swanton Wind landowner and did not advise him to get a CPG for his Met Tower. This section needs to require meaningful enforcement that addresses these problems. The new section beginning on page 14 is a long process that will not provide relief to neighbors in a timely manner, if at all. Enforcement officers are needed with capabilities similar to those of A&R, where field staff can issue immediate tickets with fines. The statute needs to include a mechanism to address issues that arise from neighbors and not just paperwork leading to penalties payable to the general fund. On page 17, lines 16 and 17 don't make sense. On page 18, section 3, the name change to the Public Utility Commission. Vermonters for a Clean Environment supports this name change only if its citing is moved to Act 250. The Act 174 working group heard from the public advocates that Vermont is the only state that has the equivalent of a PUC doing citing. The name change is an opportunity to remove land use from the PSB, something very much needed as the PSB is raising the cost unnecessarily and creating adversarial situations through expensive contested case proceedings, enriching lawyers with a record of decisions that are causing backlash against renewable energy due to poorly cited projects. Act 250 is a land use law that has made it possible for neighbors, towns, and regions to participate without lawyers and for their interests to be considered. The PSB is a utility regulatory process that requires expensive lawyers and experts to participate and excludes the interests of neighbors, towns, and regions due to the PSB's interpretation of the public good as prescribed by the legislature. Vermonters want to say in how renewable energy is cited, and Act 250 is the appropriate vehicle with modifications to the process to enable cooperation rather than contested cases. Page 21, Section 12, Citizens to PSB Hearings from Remote Locations. VC supports this provision. However, we remind this committee that Vermonters routinely complain that public hearings are meaningless because the comments are not considered by the PSB in their decision-making. Page 22, Section 13, Implementation of Working Group Recommendations. The working group recommendations are more like a Band-Aid when what is needed is major surgery. Moving citing to Act 250 is a good first step, leaving utility regulation, rates, interconnection, and the typical functions of a PUC with the board. For full participation at the PSB, intervenor funding and counsel for the public are necessary and can serve as an incentive for developers to work in collaboration with communities through Act 250 to resolve issues prior to litigation. That concludes my testimony, and I would be happy to take questions.
Okay, thank you. Committee, any questions?
You sure you're not a lawyer, Annette?
That was Senator
I'm
McDonald.
positive. It's on my business card.
Congratulations on your award last year.
Thank you very much.
Okay, thank you. That was helpful. And I'm sure we're going to be working on this one for a while, so stay tuned. Do you have any, like a written outline you could email us?
But you have it.
I have it? You've got it. Okay. So
And
they're on
it
the
has
site.
a
All
lot of
right.
links in it to the documents that I have
Okay.
referenced. So you have got a lot on your plate. I hope you will read a lot of this information because this new perspective that I have just had, I actually didn't realize until Thursday. That
Okay,
this public good needs to be defined, and public of Vermont needs a role in this, and right now there isn't one.
okay, thank you. It would be an interesting discussion.
So I do want to say that the idea about defining public good legislatively has come up at other times, and it would be interesting to have Aaron come in and to give his, give us some information about how or how not that might happen.
Yeah, we'll delve into it.
But that was, I just want to say that, Annette was, and the folks she works with did come into the working group on a regular basis. And anyone who was in the room at the end of every single meeting had an opportunity to speak and to share information. And that did help us to frame the recommendations that you now you will have, because Andrew has them. And that our goal was to increase the ease of citizen participation. It was not our charge to debate where land use planning and siting for projects would happen. So that's outside of our purview, and however, this bill does not deal with any of that.
And I'm sorry to say that I realize that as I help people participate, and then at the end of the day they say, well, why did we bother? That this really is very much within the purview of this committee that the legislature needs to grapple with. And we've come to a point where something needs to change, and it needs to enable the Vermont public to play a role in this. And as statutes are written right now, and the way the board is operating, it really doesn't make any difference if anybody participates. And that was something that I had not realized during the time that the working group was meeting.
Okay, and I think that may be a lot longer discussion and really more in the preview of natural resources. So that may be beyond the scope of this bill, but it is a very interesting concept to talk about, and I think we might be going forward with that one.
It's probably a 2-year discussion.
Yeah, I think it probably is at least that. Okay, thank you.
Thank you very much.
Okay, committee. Michael,
It's going to buzz in a minute.
push the button.
The phone button.
Just the red one there. No. I think that's it. There it goes.
So I have another appointment.
I think we all have a committee of the whole
At 4:30?
Right.
at 4:30 in the Senate chamber to go over the,
So Andrew has the recommendations. Can I?
Okay.
So I would really urge everyone on the committee to read through the recommendations, because while the current process at the board may feel dysfunctional to some, I think after testimony and after reading the recommendations that we might see opportunity for improvement.
okay. Okay, thank you. Okay, Jenny, cap and trade. Digger wants to talk to me about the cap and trade bill I sponsored.
Yeah, I'm going in to talk with him right now.
Good. Because I just
Did you
want
have
to
another
run
copy?
over until 7 o'clock tonight and,
That's good.
all right.
It's an opportunity for the administration to think outside the box.
Right. Okay, committee, that is it for today.
Wouldn't we just get ended here?
These are the working group's
That's the working
recommendations.
group's recommendation.
Those are the recommendations.
Okay.
S-52.
Committee, Chair will start. Can we clean up our own trash? Also for witnesses and
Shouldn't we
public.
clean up this already?
Yeah,
Shouldn't we clean up Mark's already?
Actually, he came in and cleaned it up. I'm more worried about the,
You're worried about
cups, bottles, yes, all those good things that, have been piling up since last week. Mark did come in on Monday, and he did straighten this out. However, it's been 14